Okay, everyone, welcome to a Rock Center webinar on unpacking prediction markets. My name is Adam Sterling, Associate Dean at Stanford Law School. A few housekeeping items. This webinar is eligible for CLE credit, so we'll put a link in the chat to provide your information to receive a certificate for CLE credit. We are also going to be hosting another webinar on Monday on Iran, energy markets, and global risk. We'll be joined by Gregory Brew of the Eurasia Group. Greg has sort of been over this story for decades and should provide some really interesting insights on sort of decisions facing boards and other organizations around this global crisis. So we'll put the link to register and join us for that webinar on Monday. And as you all likely know, the Rock Center's flagship program, Directors College, is coming up this summer. This is year 31. We have an incredible agenda. We'll put a link for more information to hopefully join us in person on campus this summer. So without further ado, we're really grateful for all of our guests, but I want to thank especially Zahi Masari. Zahi is a lecturer adjunct at Stanford Law School, teaching a financial technologies course. Zahi has taught at Berkeley for a number of years and elsewhere. And so, Zahi, thank you for putting this incredible program together. And I will now turn it over to you to welcome the rest of our panel and to kick things off.
Thanks so much, Adam. This is really fun. It's my first Stanford Rock webinar. Super excited to be here. We actually taught a little bit about prediction markets in our FinTech course this year, and I have to say it was probably the topic that was the most exciting and interesting for the students, including because it's in the news all the time these days, catching the imaginations of people around the world. So today I'm super excited to host a panel of experts on prediction markets, focusing a little bit on the legal and regulatory aspects of those markets. I'll introduce my panel and then kick it off with some questions to get us going. So first, we have Rick Heaslip, who is the General Counsel and Chief Regulatory Officer of Kalshi. I have Andrew Kim. He's a partner at Goodwin, working a lot on prediction market issues and a partner in the appellate practice at Goodwin. I have Neil Kumar. He's the CLO of Polymarket. And my colleague at the boutique law firm Arcturus, Rebecca Reddig. We'll try to do our best to take audience questions if you want to put them in the chat. We have a pretty packed agenda here, so I won't make any promises about being able to answer those questions. But, let me just start with a few remarks about, why we thought it would be interesting to do this sort of webinar today. As I mentioned, prediction markets are a front page and household topic. They're featured at major sporting events, at film industry awards, and, of course, they have the attention of regulators and policymakers around the world. There have been 6 bills introduced in the U.S. Congress looking to regulate prediction markets. There have been more than 20 federal and state lawsuits filed on various topics around prediction markets. And the SEC and CFTC, our federal markets regulators, as well as state gaming regulators, are all working to understand how these markets function today, what their risks are, and how they should be regulated. But these markets aren't new. Just as one example, in 1988, the Iowa election market was launched by the University of Iowa. That was an academic experiment. There were only 192 participants, but they ran event contracts that were designed to try to understand and predict the outcome of the Bush-Dukakis presidential election back in 1998. Those polls, the election market results, were actually more accurate than the polls of the day. But look, today's prediction markets are not academic experiments. They involve many more participants. and raise a lot of new and interesting regulatory and legal concerns that we're going to talk about today. We're not in Iowa anymore, Toto. So with that, I'm going to kick it off with a question for Rebecca, just to give us a little bit of grounding in what are prediction markets and what are we really talking about today when we're talking about prediction markets. The current chairman of the Commodity Futures Trading Commission, the CFTC, one of the two federal market regulators, talks about prediction markets like information markets. And that's an idea that was endorsed by a leading group of economists in an AEI Brookings paper in 2007. On the other hand, critics, of course, say it's just gambling. So, Rebecca, in plain terms, can you tell us what are prediction markets? What social value can they provide? And where do those views break down?
Great. Thanks so much, Saeed. Thanks to everybody for listening, and thanks to Stanford Rock for having us. A prediction market is an electronic trading platform where participants can buy and sell contracts whose value is determined by the outcome of a future event. And we call these event contracts, which I'll get into in a little bit in more detail. The price of the contract at any given time reflects the market's collective assessment of the probability that event will occur. And if the event occurs, the contract typically pays out a fixed amount, usually $1. And if it doesn't, the contract expires at $0. The type, for an example of what you'd have, a contract could ask, will candidate X win this election? And a trader who buys the contract of yes at 65 cents is saying that there's a 65% chance that the candidate will win. The seller of the contract at that price disagrees and thinks that it's a no. And whatever way it is resolved, one side of that will receive $1 and the other side of that will receive $0. And so an event contract itself is the individual instrument that trades on prediction markets. And it has a few specific characteristics. As I said before, one, it resolves to one of two values, usually $1 or $0. And the event underlying the contract is typically an occurrence, an extent of an occurrence, or a contingency associated with a financial, economic, or commercial consequence. How are these event contracts characterized by regulators in the United States? I'll give the first side on the CFTC or commodity side, and then I'll talk about your social value gaming thing very briefly to make sure we can get to all of our other esteemed and very knowledgeable panelists. But the question is, how does an event contract qualify as a swap under the Commodity Exchange Act? And the swap definition includes, and it goes back to what I said before, any agreement, contract, or transaction that provides for the purchase, sale, payment, or delivery that is dependent on the occurrence, non-occurrence, or the extent of the occurrence of an event or contingency. So there's always something conditional underlying these event contracts, and the definition is extremely broad. And where this breakdown comes to where you reference the gambling, the biggest question is there have been event contracts on sporting events, and there is a lot of interest in those. And those event contracts are dependent on the occurrence, non-occurrence, or the extent of an occurrence of an event or contingency. And as we'll talk about more, where is the line for that? And this definition of swap is so broad that it encompasses a lot. On the social value question, and I'll do this very quickly, the event contracts, one, as you said, are not new. The 1896 presidential election had event contracts. The 1500s, there were event contracts on who would be the Pope. Things are very full circle. Everything that is old is new again, because there were event contracts, I think, on both Polymarket and Kalshi relating to the decision for the Pope that happened months or 9 months ago. So those are still going on. And the interesting part of this is that there is a real information forcing function. While the majority of event contracts that are being traded right now deal with sports, there is a contingent of the event contracts that deal with financial questions, geopolitical questions, straight up political questions. And we found there to be a lot of value, including on the presidential elections or other types of elections, that seem to predict the outcome in a much more accurate way than things like polls and other things that we've used. So the information forcing function is a really important part of prediction markets. And I'll turn it back over to you, Zai.
Thanks. So we had a quick question from the audience, which is, does the seller receive money up front or only upon resolution of the contract? I'll tell you guys what I think, and then you can correct me, which is someone entering into an event contract on one of these markets will post funds up front to take their position, and then will get paid out or not later. Is that right? So you collateralize your position and then get paid out. Yes? Okay, good. Glad to hear it. Go ahead, Rebecca.
No, it's technically different. Rebecca, go ahead.
No, I know what you're going to say. Go ahead. You go, Neil.
So on a CFTC regulated exchange, you exactly what you just said, Zai, and it's going to be the same across effectively all exchanges where you post collateral up front. It's fully collateralized, and then the contract will settle. On our decentralized global platform, the way it's truly peer-to-peer, and so when a person sells and a person buys, the buyer transfers USDC to the seller, and the seller transfers an outcome token, and the transaction is complete. And then once the contract resolves, you can take that outcome token and redeem it for, as Rebecca said, each individual outcome token worth $1 or one USDC. And so depending on the number of outcome tokens you have, that would dictate what your redemption value would be.
So, Neil, this is a great way to tee up my next question, which is, I think there are structural differences between how your offshore and onshore markets operate. Onshore, and Rick, I'm going to get to you in a second about your designated contract market. But Neil, maybe you could just give a tiny bit of background for the audience about how that global offshore market as a sort of technological matter operates, and the connection maybe between sort of blockchain and crypto technology and prediction markets, because I think that's a connection sometimes people don't understand or can be confusing.
Totally. And happy to get started. Am I frozen? Can you guys see?
Oh, I think it was me. Sorry. Did you
Okay.
get the question? Yeah, sorry.
No, I heard the question. I just want to make
Okay.
sure you guys could hear me. So, Polymarket, as everyone knows it, was the global decentralized platform is a crypto platform, right? So it was built on a blockchain. It's decentralized in nature in the sense that it's a non-custodial platform. So as a platform that offers trading in event contracts, we don't take customer funds. We don't control customer funds. It's one wallet connecting to another wallet as they trade. And so the infrastructure of being built on a blockchain and being decentralized in nature is very different than what a traditional market that's registered and regulated with the CFTC, where it's centralized in nature. It's their own closed, controlled system, and the exchange would take in funds, or technically the clearinghouse would take in funds, and they sort of own the customer relationship, or the broker owns the customer relationship. And so what we faced back in, the company was founded in 2020, the blockchain-based platform was started in 2020. And what we faced was what most crypto companies faced from 2020 to 2024, which was a lack of clarity around what's the appropriate regulatory regime for crypto in general, and in particular, how do you deal with decentralized platforms that don't operate or look like what we've understood centralized platforms to look like. And so the event markets were originally, founded in New York. Event markets were available in the U.S. The CFTC at the time didn't really know what to do with a decentralized platform, and so we entered an enforcement settlement with the CFTC in 2022, and as part of that enforcement settlement, agreed to geo-block U.S. users. And that was the way to deal with the problem in the regulatory difficulties in the US, which was don't offer your markets in the US. And so fast forward 2024, 2025, we acquired a US registered designated contract market and derivatives clearing organization. And that was our method to come back into the United States under a traditional centralized exchange. And so at the moment, what we have are a global decentralized platform and a US DCM DCO that's centralized in nature. And so they're two separate exchanges. They don't sort of share liquidity. There is the US platform and the global platform as well.
Sorry, guys. Are you there?
I can hear you.
Yep.
Perfect timing.
Oops, sorry. Great, thank you. I will move on to the next question. I think I lost the end of your response, Neil, but I think it's good.
It was great.
It was amazing. I'm sure it was quite the best. So it's really good to get the background on the non-US platform. Rick, I'm going to turn now to you to talk about the US approach that Kalshi's taken with its DCM. I think actually your platform launched in 2020 as well. Maybe I got that wrong, but I think it was 2020. And maybe you can talk a little bit about how Kalshi's US regulated product works.
Sure, that sounds good. Yeah, happy to answer that question, and thank you again for having us. So Kalshi was founded in 2018, actually, and then it took the first few years of its existence essentially trying to get regulated. So after a few years of building out the back-end systems, working with the CFTC, we were regulated as a designated contract market in 2020. So we launched after getting our DCM registration. So we're now regulated under the same federal framework that you'd see for institutions like CME, for example. So there are a lot of day-to-day requirements that come with that designation. Perhaps most obviously, which would be that as an SRO or self-regulatory organization, we're legally responsible for implementing and enforcing our own rules. So we have a rule book. Every word in that rule book has been approved by the CFTC with at least 10 business days of review and collaboration. And then we have a legal obligation to enforce those rules. And then we answer to the CFTC if we don't. We also have day-to-day requirements under 23 core principles under the Commodity Exchange Act and all the rules and regulations they're under. There are probably too many of them to just run through in this venue, but I can give a high-level list to give you a flavor. So we have disclosure and record keeping obligations. So we make daily disclosures regarding our market volume and trading activity. And then we have at least 5 years worth of documentation that's open to inspection from federal regulators. We also have access and market structure requirements. So we offer impartial access to our platform. So that's a core principle that essentially requires us to provide access on a fair and non-discriminatory basis to all market participants nationwide. And that's one of the things that's currently in question, and it's one of the things that conflicts with, spoiler alert, what a lot of states are requesting of us right now. We also maintain sufficient capital reserves. We have market integrity and surveillance requirements. We have clearing requirements, and we're also subject to a lot of rules regarding the sorts of contracts that we certify and how we certify and list them. For example, we self-certify our contracts with the CFTC. They have back-end authority to review them for compliance. They can ask that we take them down. They can request written documentation of compliance with core principles, and there's a whole review process that's built in there. I think it's also worth noting how we differ from traditional sports books. As a lot of people have learned about us, even though we've been operating for 6 years, a lot of people have learned about us more recently in the context of gaming regulators and their discussions about our platform. I think it's important to draw distinctions between what we do as an exchange and how sports books operate generally. For example, unlike a casino or a sports book, the exchange is not like a counterparty to trades or positions taken by customers. So the exchange is not taking the other side of a customer's bet or trade. We're not setting odds. And more importantly, in my view, is that we don't profit when customers lose. For example, every every dollar of a casino's profit or a sportsbook's profit is their profit because a customer lost it, and that leads to a lot of difficult to deal with incentives, these sort of predatory, perverse incentives, and those are the sorts of incentives that do not exist on an exchange, where we're sort of a neutral arbiter of peer-to-peer transactions. I think that's really important because it leads to key differences in how those two products are regulated and why. It's also worth noting that a trader can exit or enter a position at any time on an exchange. So it's not like someone is locked into any position that they take. Instead, all of the transactions take place on a central order book, and just like any other trader on, trading stocks, for example, someone can always buy or sell their position at any time. So these distinctions are why it's important for, in our view, there'd be a federal regulator here as opposed to state level regulators, because we think that, broadly speaking, U.S. exchanges, U.S. markets don't operate on a nationwide basis if they're subject to 50 different sets of different regulations.
I love it. We're going to get into the controversial parts pretty soon. This is great. Thank you, Rick. That was really, really informative background. And our friend Andrew has been quietly and patiently waiting in the wings to give us a little bit of a counter view. So, Andrew, we've been talking a lot about federal regulation. We've been talking about how these platforms are structured. Oh dear. Oh, good. I'm back. That's all fine, but where do the states come in? There's been a lot of recent law, starting back in 2018 with Murphy, well, not really starting, but notably in 2018 with Murphy versus NCAA, which struck down a federal law that restricted the ability of states to regulate gaming in their own states. Since then, a bunch of states have moved forward adopting laws that regulate sports gaming, spurring development in state gaming platforms and activities. Tell us the story from the state side and the state gaming side.
Sure, absolutely. And I think that's the first time anyone's described me as quiet and patient, but I'll roll with it. So, the states, taking a step back, even from 2018, the Supreme Court decision then about sports betting, let's just take a step back uh, more broadly. The states have regulated gambling and have had gambling prohibitions on the books for hundreds of years, right? The gambling case law goes back centuries. So state regulation of gambling is centuries old. State regulated gambling is actually a relatively recent vintage, right? Nevada legalized gambling in its sort of current form in 1931, and then we've had a slow trickle, relatively speaking, of states allowing for casinos, and getting rid of constitutional prohibitions on gambling. So getting to a place where you have state regulated gambling is of a relatively recent vintage, like over the last 100 years. And then sports betting in particular has had sort of a rocky history because in 1992, Congress passed the Professional and Amateur Sports Protection Act, which basically said no state can pass a law allowing for sports gambling. You need to maintain the prohibitions that you have on the books, except for a handful of grandfather states. So Nevada was the big one that was grandfathered. And then Delaware, Oregon, and Montana had these weird lottery products that like very few people play. Like, I think Delaware had like a parlay product or what have you. And it's very limited in appeal and scope, and it was all mostly done retail. Online sports betting, even for most of the 1990s and 2000s and most of the 2010s, even online sports betting was not very much not a thing. But then you have the Supreme Court say in 2018 in Murphy versus NCAA, you have the Supreme Court say that requirement that states continue to prohibit sports betting, like that's unconstitutional. It violates the 10th Amendment's anti-commandeering principles. You can't conscript the states into maintaining this prohibition for you. So all of a sudden, you've got the floodgates are open. It takes a while for the flood to trickle in, but the floodgates open, and all of a sudden, we live in an environment where now we have 39 states in the District of Columbia with sports betting, legalized, regulated sports betting. You have 31 states or 31 jurisdictions offering some form of online sports betting. And it's, you have to remember, it's been fewer than 8 years actually since we've been able to, use this readily to try to place money on the outcome of events. And as more states got into the business of betting and wagering, and not just the business of prohibiting it, but actually in the business of betting or wagering by regulating it, by taxing it, and by building budgets around the tax revenue that they were expecting from sports betting, they increasingly grew into their view that they have primacy over all things that look like gambling, because under Murphy, especially in light of Murphy, rather, they viewed gambling as a state issue. Now, where do prediction markets come into all this? Like, prediction markets did not surface on gaming regulators' radar last year. It's that they hadn't had to really react to them just because the CFTC, of where the CFTC had been historically with respect to prediction markets. For example, if you take in 2021, a company called RSX self-certified NFL sports events contracts. There was let's just call it a robust discussion within the commission about the contracts, and ultimately RSX pulled the contracts down because of the commission's intervention. So that's just one illustration of that. The states really didn't need to put a lot of thought into, like, what do we do about prediction markets? But then in December of 2024, you have the first Super Bowl contract being self-certified, right? At least within the last 2 years. And then you have a wave of sports-related self-certifications after that. And the CFTC is not acting on these self-certified contracts. And so the states are going, wait a minute, this seems like
Sorry, Andrew, I don't mean to interrupt your story,
Sure.
but could you explain what it means for the contract to be self-certified? I'm not sure that.
I feel like I am the least qualified person to be commenting on this. But
Got it. So I can do it
yeah,
if you like.
if you want, I
Whatever.
can, but my description will pale in comparison to yours. So go ahead, Zai. Oh, never mind.
Okay.
So my a designated contract market that's registered with the commission can list contract in one of two ways, right? You can get approval from the commission, but then there's also a process of self-certification where you certify that you've complied with the requirements of the core principles, which are the governing set of principles for CFTC regulated products, and that you meet all the technical requirements as such as well. The CFTC has a certain amount of time to act on those contracts, and can for certain types of contracts, which I'm sure we'll get to in a second, but for certain types of contracts, it can take the position that the contract is contrary to the public interest, place the contracts under review, and then prohibit the trading of those contracts if it determines that the contracts are contrary to the public interest. And Rick, Neil, and Zai and Rebecca will all correct me but that's like an oversimplified description of like how this process works. So you have the contracts being self-certified. The states are going, well, wait a second, this seems an awful lot like sports betting, right? This seems like betting or wagering. And why do the states think that, right? We have in gambling law, we have a long established understanding of what constitutes a bet. And it's not just, you may have heard about, is it a game of skill? Is it a game of chance? It's actually more than that, because, and we went through this with daily fantasy sports, when the daily fantasy sports operator said, we're a game of skill. And the states said, that doesn't matter, because gambling prohibitions actually come in two sets. There is a prohibition on games of chance in many jurisdictions, but in many other jurisdictions, there are prohibitions on bets or wagers. And what is a bet or a wager? If you look at New Jersey's definition, for example, it defines gambling as staking or risking something of value upon the outcome of a contest of chance or a future contingent value or future contingent event not under the actor's control or influence upon an agreement or understanding that the actor will receive something of value in the event of a certain outcome. Uh, and so this has been a common law understanding and a statutory understanding of bet or wager or gambling for at least 100 years. It's two different buckets, games of chance, and then money placed on events outside of the participant's control. And so the states are saying, gee, like money is changing hands in these event contracts based on the outcome of events. Why isn't this betting? Now, Rick gave you a spoiler alert on the state gambling side. I'm going to do a spoiler alert for something Rick's about to say, which is, uh, uh, to take a step back, as Rebecca had teed up at the outset of all this, the CFTC has jurisdiction over swaps, and it's not just jurisdiction, but it's exclusive jurisdiction over those swaps and other derivative products. And the CEA also has a provision that says the act isn't going to preempt any transaction that's not conducted or conducted on or subjected to the rules of a regulated entity. And the supremacy clause broadly stands for the proposition that the federal law is the supreme law of the land. So why do the states think that they have a leg to stand on here? Why do they think that they can prevail? Well, I go back to where I started, which is gambling has traditionally been a state regulated issue. States have regulated gambling for centuries. This looks an awful lot like, and this is where unstoppable force meets a movable object. Like you have a very broad definition of swap. You have a very broad definition of gambling, betting, and wagering. And the states are saying in the preemption case law has developed in such a manner that if it's an area that's been traditionally regulated by the states, which I don't think anyone is disputing, you need a clear expression by Congress to displace the states from their ability to regulate. So the question here is the grant of exclusive jurisdiction and the manner by which the act has provides for non-preemption, is that clear enough to kick out state gaming regulators and leave the CFTC the sole regulator of these event contracts? And I'll just add one more thing, just to stress that the debate has largely been about sports events contracts because that's where the money is. That's where regulated gaming is right now. But the gambling prohibitions aren't limited to sports. The licensing regimes, some of them aren't even limited to sports. Like Arizona has a regulated licensing scheme for event wagering. And so it's about more than just the sports, right? Conceivably. And some of the cases have involved election contracts and other types of contracts. So the ultimate question is, why would Congress give to the CFTC the power to oversee these contracts if the states can intervene and put their own restrictions on them? And did Congress really think about that? And setting that aside, even if Congress wasn't clear, can you comply with sort of both sets of regimes, or is that too much of an obstacle, too much of a conflict between the two for the states to really play a role here? So I'll just leave it at that.
Rick
Andrew, that was masterful. Hold on, everybody. I get to read the money. I knew I was never going to be a litigator when I was in law school, and I feel like, is this what moot court was like, you guys? This is so good. So I definitely want to give others a chance to jump in on this, right? Including like Rick, because Kalshi is involved in some of these lawsuits directly. Rebecca, obviously you're excited to go, but let me turn it to Rick first. I want to give you a chance if you want to go before Rebecca, because first Andrew name checked you, and then second, Kalshi's been involved in these lawsuits for some time and certainly has a point of view.
Yeah, thank you. So our position on this is pretty simple, which is that the CFTC already provides very comprehensive expert oversight of all of our markets. It already has the tools and the expertise and the legal authority, of course, to regulate us. So they're really the right regulator for the job. Right now, we're engaged with, I think, in now 12 states, maybe 13, with largely state gaming regulators who are making an argument that's really been made for hundreds of years, which is that derivatives trading is subject to state regulation as gambling. This is not a new argument. like over 100 years ago, grain futures were considered gambling in grain. A pox on the nation. There's a lot of very colorful language about how derivatives trading was a huge moral hazard. And there's also a long history, of course, of the regulation of bucket shops, where stock trading was considered gambling as well. Uh, Now we have event contracts, but we've had them for a couple decades now at least, where people can get financial exposure to an event. And so a lot of people are viewing that sort of derivative as gaming or gambling. Um, Colloquially speaking, that's an open question. A lot of people today view options trading as gambling. Gambling as a behavior is just a different thing than gambling under, a regulatory or legal standard. A lactose intolerant person who has yogurt for breakfast is probably gambling in some respect, but that's different than what regulated gambling is. So there's a real important distinction to be made between sort of colloquial gambling and the regulatory authority over a specific type of product that is traded on a regulated exchange. Here, our belief, and we think the law holds us out, is that the authority for event contracts is at the federal level with the CFTC. And I'd be remiss if I didn't brag a tiny bit and say that I'm very happy to have learned just this week that the Third Circuit Court of Appeals agrees with our conclusion there, which is great. I should also well, I'll get to that actually. Our legal argument rests on a few pillars. The first is express preemption, which is just the plain language of the Commodity Exchange Act. Section 2A grants the CFTC exclusive jurisdiction over transactions involving swaps that are traded on a DCM like us. The plain language of exclusive is pretty obvious. It denies jurisdiction to other regulators. And that would just broadly preempt any other sort of state gaming regulation over what happens on a national exchange. There's also conflict preemption, which is essentially saying that we can't comply with both the federal regime that we have to comply with and 50 different sets of state regimes, which often have conflicting terms. State gaming regimes, some of them are better than others, but broadly speaking, they're not built for a national exchange. And so they have requirements in them that just don't make sense with respect to how an exchange operates. For example, it doesn't make sense for us to have some kind of minimum collateral to collateralize the other side of trades because we are a peer-to-peer exchange where the collateral is provided by users. We're not actually taking, the quote unquote bets against users. We're a neutral exchange. Similarly, a lot of state laws say that all transactions need to take place within the state itself, which obviously directly contradicts what we are as a national exchange. So conflict preemption is a big one. Another thing to note is congressional intent here. So Congress really did not want derivatives exchanges, commodities exchanges to be subject to 50 different sets of regulation. And so it's kind of all over the Commodity Exchange Act there's a lot of evidence for that. For example, a lot of folks think that if anything has to do with gaming, then, Congress didn't really contemplate it as a problem. But not only do we have the long legislative history of, a lot of folks, especially states, saying that derivatives trading is gaming or gambling, but we also have the special rule, which is 40.11 of the Commodity Exchange Act, that explicitly contemplates contracts that relate to gaming, and it says essentially this is subject to discretion of the CFTC of whether or not to allow these, subject to whether or not they want to give a public interest review. But Congress explicitly thought about this, and it very clearly put it within the purview of the federal regulator. Kind of implicit in all these arguments is sort of the final point, which is that our contracts are swaps under the Commodity Exchange Act. The statute definition of swap is very, very broad. It's a contract for payment dependent on the occurrence, non-occurrence, or extent of the occurrence of an event or contingency, and contingency is important too, associated with a potential financial, economic, or commercial consequence. So that's a very broad definition, but it's not limitless. I couldn't certify a swap based upon what outfit my neighbor is going to wear tomorrow, unless my neighbor perhaps is a very famous person who will their choice of outfit might have some influence over some brand value. But my neighbor is not a famous person, and so I could not certify that contract. Sports and elections, on the other hand, very obviously have financial consequences, major ones for, sponsors, advertisers, networks, franchises, local economies, hotels, you name it. So it's pretty clear that a sports contract in particular, an election contract, very obviously, they're associated with potential financial outcomes, and so they would be designated as swaps. So those are sort of the pillars of our argument. We're fortunate that we've had some courts agree with us as of late, which is great. And we're also fortunate that the CFTC only recently has begun to intervene in some of these cases to defend its own jurisdiction and to kind of make clear that it is very capable of regulating these products.
Thanks, Rick. Well, I'm going to jump in and modify the direction for the question for Rebecca, Neil, and Andrew to jump in as they like. So I think it's pretty clear what Kalshi's position is in the US. Neil, I think the position of Polymarkets for its US markets is largely the same. You'd prefer federal regulation than state by state gaming regulation. There's a bunch of court cases. Like, what is, from all of your perspectives, like, what's the durable long-term result that you'd like to see for these markets? And is the current sort of path that we're on the durable one? What happens when there's a change of administration? How much does the political environment affect the regulatory outcome here? I'll let anyone jump in. Or no one.
I go ahead, Neil.
I'm happy to take a stab at it, but I think the outcome that we certainly would like to see is the CFTC regulates swaps and in particular products traded on a CFTC licensed exchange, and states regulate sports books, and states regulate state gaming entities, right? Like I think there's a bit of a straw man argument that what the CFTC is trying to take something away, when what they're trying to do and what we think is the right answer is they're going to regulate the exchanges that they've regulated for a very long time. And there's going to be choice in America. And who's going to win and who's going to survive is based on commercial choices that Americans are going to get to make. And so the end result that I'm hoping for, and we're not subject to as many court cases and court processes, but we're in a few of them, is that the court system is going to play out as it would, and obviously both Polymarket and Kalshi think, and the CFTC think we're right. That process will play out as it does, and if we're right, you'll have the opportunity to choose the venue that you think is most appropriate for you. And when there's competition, consumers win. And that's the outcome that I think that we're looking for. In terms of changes in administration, that's a risk that every business in America is subject to every 2 years, right? And well, for a change in administration, it's every 4 years, but changes in Congress can have those impacts as well, right? And I think it's incumbent upon the exchanges to develop a set of processes and come up with a product that is defensible. And the law is what it is, and so if Congress has the ability to change the law, then that we'll all have to make adjustments and change our products. But to the extent the law stays the same, we would expect the next administration and whoever's leading the CFTC to follow what the law is and to follow what the law says.
So I'll jump in on 2 points, probably both of which Andrew will come at me for. So maybe I'll pause after the first one. But I do want to put a fine point on what Rick and Neil were saying, and to go back to what Rick had previewed. But the Third Circuit decision from earlier this week, so the Third Circuit for the U.S. Court of Appeals, so just I know not everybody on here is a lawyer, but like district courts are the lowest courts. It's where you start duking it out. If you don't like the outcome, usually some party isn't happy with it, you bring it up to the intermediate court. And if the intermediate courts in different parts of the country disagree, or there's some other very large question, then it goes up to the Supreme Court. So it's likely that we'll see something in the Supreme Court on this issue because while there is a Third Circuit case, there's a Ninth Circuit case, there's a Fourth Circuit case, and it's not just that Kalshi or Polymarket or other private companies are going up against the state gambling regulators. It's also that the CFTC and the states are having their own individual suits on this. So the CFTC has sued Illinois, Connecticut, and Arizona on this as well. So one would expect to see this go up to the Supreme Court. The second thing is the Third Circuit opinion from this week does say the CFTC has exclusive jurisdiction on what is going on prediction markets, and anything that is going on off market in these state gaming platforms is regulated by the states. The other thing that the majority opinion, because it was a 2-1, there was one judge dissenting on the Third Circuit, said that it is also impossible for prediction markets to comply with the federal regime and the state regime at the same time. I would say everybody should at least read the first page or two of the dissent because the judge talks about how he went on to Kalshi and went to go wager, which I've just found very delightful as somebody who is a litigator, at least in my former life. And
She's 91 years old, by the way.
I mean, love it. It's also, there's another very
The
old
judge, not Rebecca, you mean, of course.
No, yeah.
At first I was like, wow, really coming at me, Andrew. This is getting spicy. But yeah, that is an amazing fact, actually. And it's very much like there was a very spicy case in the crypto world 2 years ago where a very old judge also made like very interesting statements about very interesting pieces of software. So it reminds me of that. So that's the first piece on that. Andrew, I'm going to pause. Do you want to take issue with anything I said or put a fine point on it before I move to the next one?
No, I think the Third Circuit, you're looking for controversy here. And first of all, the views I express here are not my personal views or the views, I'm kidding. But
no, they're only your personal views.
And not the views of my clients or my firm. But no, I don't disagree with anything you said, Rebecca. And I think that looking at the Third Circuit's decision, both in terms of the majority opinion and Judge Roth's dissent, really does capture where the legal debate is right now, right? Judge Roth has taken the view that the majority gave short shrift to the presumption against preemption. And, the panel didn't ignore it. They spent some time talking about it. But at the end of the day, that's what this boils down to is like, how much of a head start do the states get in terms of the preemption analysis? And Rick is absolutely right, which are words I'm sure he's surprised to hear. But Rick is absolutely right. Like the line drawing about what is federally regulated speculation versus state regulated gambling has been a debate that we've had for over 100 years. I mean, states try to outlaw contracts for future delivery as gambling for a good number of decades in the late 1800s and the early 1900s. So this is not a new discussion in terms of the federal analysis. The federalism analysis, but it's not an easy discussion, I would say. I think the states, it's not as if the states are coming from a frivolous position. Do I agree with the states? Half the time, no, but I think that's not to say that their arguments aren't credible. I'll just pause there and toss the ball back to Rebecca because there's a point too that I think she wanted to discuss.
No, I really wanted to move on to the question that is there about what is going on outside the US. So are you ready to move?
Yeah, let's do it. So, Andrew, or do you want to make
No, I just wanted to dovetail off of something Neil had said about, the future administration. One, I think it is a great thing that the CFTC is engaging in rulemaking in this space because the more rules that we have, the more clarity that we have, the more of a sense of finality that you have. And it is once there are final rules in place, it is, as someone who sues the federal government with some regularity, like that is harder to unwind, right? So once you go through the notice and comment rulemaking process, once you had a set of final rules, I think that gives a firmer foundation, legally speaking. And the other thing too is that at some point, the more established that these prediction markets get and the longer that these contracts are being offered, the more arbitrary and capricious it might seem, and to use APA parlance, to turn off the spigot right away, right? To turn the tap off right away. And I think the agency would be in a difficult position to explain it about phase 5 years from now. So all that is to say, I think in terms of giving permanence to the industry, I think the rulemaking is a step in the right direction. And also, it is not as easy for an adverse administration, even if it were adverse in the next one. And, hopefully the industry will engage in discussions with the next administration, but not that I'm thinking that far ahead. But all that said, it is harder for an agency to do an about face than one might think, given the protections provided by the Administrative Procedure Act. So I'll just leave it there.
So Rebecca, hold on. I get to be
Nice.
moderator at the moment. So we were going to talk a little bit about the non-US view of these markets. But I think I'm going to pivot instead to a question that's come up in the chat, which is insider trading. And I know it's a topic that comes up a lot in the public discussion. I think all of you have faced many questions about this in your roles, either at prediction market companies or as outside counsel. So I'll just give 2 seconds of background. Hopefully my internet connection holds. But, we have laws in the securities world on insider trading. Most people are quite familiar with those. Prohibit insiders from using information they get as part of their employment or otherwise by virtue of having a role of confidence in a company to profit by trading in securities in breach of that confidence. I'll contrast that with the way insider trading has evolved in commodities markets overseen by the CFTC. Historically, there actually really hasn't been a strong view against insider trading in commodities markets because there just isn't the same kind of concerns about what corn crops look like or how much oil is coming out of the ground because of the dispersed nature of corn growing and oil drilling. And so, in fact, in commodities markets for a long time, in fact, before 2010 with Dodd-Frank, there wasn't a prohibition on insider trading. And with Dodd-Frank, you have a prohibition on insider trading, but it usually pertains more to intermediaries front running and spoofing and doing other sort of bad market activities. So into this, we bring prediction markets, which I think, to be honest, have characteristics of some securities activities and also have characteristics of commodities activities in different regards when you think about the risks and concerns about insider trading into the integrity of the market, the use of confidential information. So with that very long wind up, I'll turn it first, I think, to Rick and then Neil, and then Rebecca and Andrew to sort of wind it up. Tell us how you're thinking about insider trading, how your companies are thinking about it, and how you think we move forward, because I think there are real concerns here.
Yeah, happy to. So I totally agree. It is insider trading is slightly different in this context as opposed to in a securities context. But they do have a lot of overlap. And the way that exchanges are operating, it serves to protect the markets in a major way. We think that broadly we're anti-insider trading, to make it very blunt. We think that it is dangerous to the markets. If people are suspicious of insiders, they don't trade. If people don't trade, there's not liquidity. If there's not liquidity, then pricing worsens, and it ends up really undermining the entire purpose of a regulated exchange, the purpose of a market. So we address it in a lot of ways. We have the misappropriation framework under the Commodity Exchange Act, but we also have prohibitions against, folks who trading that can influence the outcome of an event. And there's also a lot of behavior that colloquially might seem like insider trading, but it's banned under a different name. So like market manipulation, for example. Generally, we have a layered approach here. We start by collecting information, either collecting it from third parties or in the public sphere, and using that information to stop people from making these trades before they even try. So we have full KYC information as a regulated exchange, and so we can take KYC information, we can take information from partners like IC360 and who has lists of people who might be associated with a given sports league, for example, and then we bar those people from trading before they even get the chance to. We do the same thing for members of Congress, by the way. So there's a layer at the outset that stops these from happening before they can, but that layer isn't not perfect. Nothing is, and so we also have round-the-clock surveillance, where we have surveillance systems that throw up flags, and then we have 24-hour surveillance officers who take shifts. They look at all these surveillance flags, they investigate the flags, they take tips from outsiders, and then they put all that into their investigations. Those investigations take the form of interviews, take the form of data and document collection, and then they eventually will lead to exchange discipline. Exchange discipline can look like being barred. It can look like fees or fines. And it also looks oftentimes like a referral to the DOJ or to the CFTC for further disciplinary action. So we tend to defer to them when it comes to these investigations. So we'll follow their lead if we raise something to their attention and they want us to investigate it in a specific way. Broadly, I think this framework is really valuable. We think that prediction markets and exchanges are just by far the better, more consumer-friendly, safer model when it comes to that model.
Great, thanks. Neil, do you want to jump in? I think you were so still, I thought you were frozen.
Yeah, no, I guess just like raise your hand or something if my connection drops out. But it seems like we're all having technical difficulties today. And just to give just a tiny bit more background on the CFTC's approach to insider trading, which is in general the approach we follow, and that is the reason it's different from the SEC is on purpose. It's not that the CFTC hasn't thought about it. It's not that the CFTC doesn't care about it. These are different markets that require a specialized set of rules. And so the classic insider trading has not been banned by the CFTC because there are people with unique sets of knowledge about their markets that they are incentivized to bring to the market. The reason you have price discovery on the future price of wheat is that farmers can trade and they don't have to disclose what the background is of the information that they have to give it to everyone. And that's how you get that's how those markets allow for hedging. That's how those markets allow for price discovery. And the same is true for event contracts. And so you're allowed to take your own specialized set of information and bring it to the market. Now, that doesn't mean everyone can trade on any type of information they always want that they want to. And the way the CFTC has approached it historically and the way we think about it is if you have a duty not to trade on information and you trade on that information, that's against the law. And it's called misappropriation. You can call it theft. You can call it's really theft of information, right? You have information that's supposed to stay confidential and it doesn't stay confidential and you profit off of it. So if you're a government employee and you trade on confidential information and you profit, whether you profit on it or not, it's illegal. And so that's our baseline for what we prohibit and what's banned on both our global platform and our US platform. For event contracts, there is a little bit of nuance, and this really gets to more like the manipulatability of a particular contract. And so we also ban people who have enough authority or influence sufficient to change the outcome. So if it's a mention market and it's a mention market about you can't trade on it because you can easily manipulate the contract. And this gets to a little bit of what Rick was saying. That's just as much a commercial consideration as it is a surveillance and legal one. If people don't believe in the integrity of the market, they don't want to trade it. And that's the best sort of influence for why we have the robust surveillance system that we have. Like, you don't have to just believe us that we're doing these things, because we are heavily incentivized to have healthy markets. Because again, if they're easily manipulated, you have very little incentive to want to trade it and try and trade it. That doesn't mean, of course, We take our surveillance responsibilities very seriously. We are frequently referring matters to the CFTC and the DOJ. We are frequently conducting our own investigations, same as what Rick was saying, running interviews. We have, front-end surveillance, back-end investigations. And so that's part and parcel of being a CFTC regulated institution. And we do the same on our global platform. But again, insider trading, obviously front of mind for everyone. I think important to note that, again, banned on our platforms. And I think we could probably do a better job of shouting that from the rooftops. We've created a specific market integrity page just to really highlight what was already in our rules so people can very easily find that. But I think prediction markets could be doing a little bit more to show and say, like, these things are banned and there's surveillance that goes into it. And it's an important component of what we do as a platform.
Well, I think that statement, you got to start on shouting from the rooftops today a little bit, at least for the audience here. So with that, I think, Adam, our time is up, and that is the webinar. So I'll turn it over to you.
Thank you, everyone. Fantastic session. Thanks for all of your questions and comments. Sorry we did not get to everyone, but we had a packed schedule. As a reminder, the CLE link is in the chat, but you can email us at rockprograms@law.stanford.edu if you have any issues. And we hope to see you all on Monday for our next webinar on Iran, energy markets, and global risk. Thank you, everyone.